I'm Drew Stevenson, and this is a lecture about United States versus Mead Corp, a U.S. Supreme Court decision from 2001 related to administrative law. And this is the case that really brought us Chevron Step Zero. Now, as a quick aside for my students, this is one of the most famous or important cases in administrative law, and it's in the Chevron line of cases, which is about judicial deference to agency interpretations. Just as a quick recap, Chevron is about when we have a statute and that Congress basically addressed to an agency and entrusted a specific agency with implementing it. And that agency's interpretation of ambiguous terms or of gap filling when the statute is silent should receive some deference from the courts. If there's a term like substantial or reasonable or material, and the agency has to decide what to do with that, or the statute simply doesn't address a point that keeps coming up, the agency has to decide how to move forward, that the courts should give deference to that as long as the agency's reasonable. That's Chevron. Now, the question, though, comes up that agencies are interpreting statutes every day, and that not everything looks like Chevron. Not everything is they're taking a statute and promulgating a regulation out of it. So Chevron left a little bit unanswered this question of when does Chevron itself apply to an agency interpretation? And that is the case in Mead. The issue in the Mead case is, when does Chevron apply? So let's look at what happened. So whenever you're reading an administrative law case, start with the statute, start with the agency. The statutes really matter. You should be, if you're a person who likes to highlight in their casebook, you should highlight the quote from the statute because it really matters in administrative law. So we have a tariff statute, and I'm not going to give you the section numbers and stuff right now, but they're in the opinion. The tariff statute basically allows for the taxation or to impose taxes on imported goods from other countries. And the Customs Service is the agency that is supposed to deal with these customs or tariffs. The Customs Service is really housed within the Treasury Department. It's a subdivision of the Treasury Department. And the statute actually explicitly gives the U.S. Customs Service authority to issue ruling letters about specific imported items and from a specific importer. You could almost think of these as almost like a little declaratory judgment from an administrative agency or an advisory opinion for a particular individual and case or company. And so these will set the tariff classifications for specific imports under the statute. It's a little stronger, though, than just an opinion, right? This actually is going to be how much you owe on your imports as a specific importer. Now, note that even though these rulings are binding with respect to the specific imported good in question and identical items, the established regulations make clear that these ruling letters can be changed without notice, and they're only really for that party. No one else can rely on someone else's ruling letter or rely on your ruling letter in connection with any transaction other than the one described in the letter. So ruling letters can be issued either by headquarters or by any of the 46 port of entry customs offices. They don't have to require notice and comment rulemaking like under the Administrative Procedure Act in Section 553. Most of them don't even contain reasoning or explanation. They just say, here's how much you're going to have to pay in customs. We're classifying your boatload of imported goods as this. Now, the opinion in the ruling letter in this case does actually contain very detailed reasoning, but we'll come back to that later. Now, here's a quote from the case itself. Importantly, these ruling letters do not carry the force of law. They are not, like regulations, intended to clarify the rights and obligations of importers beyond the specific case under review. In other words, these don't create a statute-like rule like other regulations do that applies going forward to everybody. Now, our other party in this case is Mead Corporation. They make office supplies and three-ring binders and trapper keepers and so forth. And they were importing day planners. The case actually specifically mentions three-ring day planners, which I've discovered are hard to find. Most of them are either six-ring binders or spiral notebook day planners. But these, be that as it may, these are little binders with calendar pages and for keeping track of appointments and due dates and address lists and so forth. And the tariff statute itself has these different categories and imposes a 4% tariff on, quote, bound diaries, notebooks, and statute address books, memo pads, letter pads, and similar articles. But then there's a kind of other category that has no tariff or doesn't have to pay customs at all. And the ruling letter is, these ruling letters decide your boatload of imported items, which category does it go into? And then that category has already been set by statute, how much tariff you're going to have to pay. Now, for many years, the Customs Service had treated Mead's day planners as falling into the tariff-free other category, so they didn't have to pay customs. In 1993, remember, this is when we have a new administration that won the White House in 1992, the Customs Service suddenly changed its position and issued a ruling letter saying that these day planners were actually diaries, bound diaries, and therefore were subject to the 4% tax rate. Well, that's a big loss in profits for Mead. They're basically going to have to pay a 4% tax on all of the day planners that they have produced in plants overseas and brought to the United States. So the legal question here is whether a day planner is a bound diary or not within the meaning of the tariff statute. And that is what the Customs Service answered. And that's the question then that we are going to talk about. How much deference should the court give to the Customs Service's answer to that question, as opposed to the court deciding the answer for itself? So the Customs Service wanted the court to give it Chevron deference for its interpretation, but it couldn't convince the lower courts or the Supreme Court to do that. Here's another quote from the Mead opinion, the majority opinion. A tariff classification has no claim to judicial deference under Chevron, there being no indication that Congress intended such a ruling to carry the force of law. And these quotes kind of matter. So the court is saying that Congress didn't set it up so these ruling letters would be law, so therefore the Congress didn't intend for them to receive Chevron deference, which is what the agency wanted. Remember, if they get Chevron deference, they're usually going to win and get to do what they want because it's deference. Now, but all is not lost, and this is an important point to get from Mead. So the court says Chevron doesn't apply. So, oh no, what does that mean? Does it mean that the agency loses? No, not so fast. The court still decides that this ruling should get some respect or some deference under a persuasiveness standard based on an old case from the 1940s called Skidmore v. Swift. And so this is part of the big takeaway or holding from Mead is that when Chevron doesn't apply to an agency interpretation like here, then we fall back to the pre-Chevron line of cases that went from 1944 to 1984. That's Skidmore. So if we don't give Chevron deference, we might give Skidmore deference, we call it. And I've made a separate video about the Skidmore v. Swift case that I hope you'll watch. So the other big takeaway from Mead is that there's an antecedent step before we apply Chevron, and that is to decide whether Chevron even applies. And so how do we know whether we should give Chevron deference? And that's the Mead question. So I made a diagram. Here's the diagram that goes through the Chevron steps that I hope are familiar. And now we had to add another antecedent step from Mead. Now, the court doesn't call this Chevron Step Zero, but law professors, we've got to call it something if we have a step in the decision-making process. And we can't call it the first step because we've already called another step Chevron Step 1. So professors started calling this Chevron Step Zero, and after Mead. And Chevron Step Zero is the question, does Chevron apply at all? And how do we know? Well, that question is really, does the interpretation have the force of law? If it has the force of law, if yes, then we go to Chevron Step 1. And that question is the relevant statute ambiguous or silent on the question? If it's not, if it's clear, the agency just has to do what the statute says. But if yes, if it is ambiguous or silent on this question, then we would go to Chevron Step 2. And then we ask, is the agency's interpretation reasonable? Even if it's not the interpretation the court would have come up with on its own, the court is supposed to let the agency's interpretation stand as long as it's not unreasonable. This means the agency is going to win over 90% of the time if we get to Chevron Step 2. But remember, before we apply Chevron, we have to ask, does Chevron apply? And we answer that by asking, does the interpretation have the force of law? That is Chevron Step 0. I made another diagram. And so let's look at how Chevron Step 0 works, again, as sort of a decision tree. So we start with Chevron Step 0. That's from Mead. That's the Mead question. And either Chevron applies, and if not, then Skidmore deference applies. If Chevron applies, then we go to Step 1 of Chevron. Is the statute ambiguous? And then Step 2, if so, is the agency being reasonable? If Skidmore applies, we go to what we call the Skidmore factor. So it's not a tidy little one step, two step. Instead, it's a collection of factors. What are those factors, you may be wondering? I made another graph or diagram for you. These are the Skidmore factors laid out in plain sight here. So the court in Skidmore starts with sort of the big picture. We're only doing this if the agency has expertise and experience in this area. In other words, the Environmental Protection Agency knows a lot about the environment and pollution. We don't think they necessarily know anything about financial markets. And conversely, we think that the Federal Trade Commission or the Securities and Exchange Commission knows a lot about financial markets and currency rates and things like that, but might not know that much about pharmaceuticals. And so we're assuming when we apply Skidmore, the first thing is this what the agency knows a lot about? Is this what they do? Do they have a lot of experience in this area? And then we go to these next three questions, the validity of its reasoning. So if it makes some good arguments, that's a factor that counts for the agency, even if a court, a highly trained lawyer or court could have answered each of those arguments. Is the reasoning valid and sound? Secondly, the thoroughness evident in its consideration. How long did the agency spend studying this? How much did they document their deliberations? Did they commission studies and do surveys and have meetings to discuss those studies? And how much of a paper trail is there so that how much did the agency really show their work is what we're asking. And then the consistency of the agency's interpretation with other previous pronouncements. Has the agency changed its time and contradicted itself again and again over the years and case to case? Or has it been really consistent and everybody's been relying on a certain, assuming the agency would do the same thing, and then the agency out of the blue ambushes everyone and changes things? So consistency is going to give us more weight for the agency. An abrupt change out of the blue is going to make a court more skeptical. So those are the first three. But don't forget the catch-all category at the end of the Skidmore factors, all other factors that might make the agency interpretation persuasive, like what's at stake here? How clear is the statute? How much is the agency basically in lockstep? Or how clear is the statute that Congress really wanted the agency to make decisions just like this, or committed more discretion to the agency, on and on. There could be a number of factors involved here. How consistent is the agency across different types of parties? So, but again, validity of the reasoning, thoroughness evident in its consideration, consistency over time, and then any other factors that make the interpretation persuasive. Are you getting bored? Here's a picture of my dog, Lucy, to cheer you up. Now that I have your attention, let's keep going. The court declares that, now, so why doesn't Chevron apply? Well, the court says that they don't think Congress wanted it to, and that a good indicator that Congress would have intended Chevron deference to apply is if Congress had authorized the agency to engage in rulemaking or formal adjudication, and that the agency had employed these procedures, either notice and comment rulemaking or formal adjudication or formal rulemaking, some sort of like big deal, something sort of ceremonious, when promulgating the regulation. But that's not what happened here. When the court turns to the Customs Office ruling letter at issue in Mead, the letter really appears to just be the product of what the APA would call an informal adjudication. In other words, the agency had to make a decision about Mead's case, right? Mead has a shipment of day planners and needs to know, are they paying customs or not? And so that's an individualized decision, and that was issued without extensive procedural safeguards. And so the court holds that this is it's legally valid, but it doesn't have the force of law, in the sense that it's not creating law that other parties, that third parties who aren't even involved in this case, might later have to follow or be bound by. It's just the decision about what Mead has to do. Now, the court also notes that these ruling letters are produced in a high volume by lower level customs officials. And that seems to suggest this further undercuts the idea of the need for Chevron deference. In other words, to tie all this together, agency interpretations are entitled to Chevron deference only in cases where Congress would have wanted the Chevron to apply, and the court thinks that's unlikely here. So, would we have gotten a different result in this case if Chevron had applied? Probably not. At Chevron Step 1, this court would have concluded that the text is ambiguous. It doesn't really say if day planners or diaries, and it probably would have found that the agency's interpretation is reasonable. Remember, the agency really went into detail about why, describing the binding of these day planners and the materials that they're made out of and things like that. And so they articulated a lot of plausible sounding reasons for their classification. So I think they would have won under Chevron anyways. And the standard they applied, Skidmore, is still pretty deferential, even though it's a host of factors that we weigh against each other instead of a series of logical steps or a flow chart. On the other hand, in common parlance, day planners are not diaries, right? If you asked for your parents to buy you a diary and they bought you a day planner, I think you would be justified in being a little disappointed, right? You wanted a book with a pretty cover and binding that has blank pages where you can record your deep thoughts and feelings and reflections and things like that, and not something that looks like an appointment book. And a book for writing phone numbers and keeping track of deadlines and lunch dates and so forth. But so I think you could have made an argument that the Customs Service interpretation is counterintuitive or goes against the common usage or the way people normally talk. But honestly, the way the court was applying Chevron in this era, I think that the agency still would have won if Chevron had applied, and they knew that, and that's why they wanted the courts to apply Chevron. Now the court focuses on procedural formalities here, and there's a question about whether it's a necessary condition for Chevron deference or a sufficient condition. And what I'm going to do is go off slide and just explain what I meant to say here. Basically, the court in Mead makes a big deal out of the fact that the agency didn't do notice and comment rulemaking here, and in fact they didn't have to under their statute, to kind of support the idea this doesn't have the force of law, and therefore Chevron is not triggered. And Justice Scalia, in his dissent, makes a big deal out of that. And the fact is, in subsequent cases after Mead, it turns out that question, notice and comment rulemaking, isn't the be all and end all. There are some cases where an agency went ahead and did notice and comment rulemaking for some kind of interpretation, and the court still decided that Chevron didn't apply, Skidmore applies, and right under Mead. And there's cases where the agency didn't do notice and comment rulemaking, they skipped that step, and the court still thinks it has the force of law and gives Chevron deference. So it's a factor, but it's not the only factor or a dispositive factor necessarily. It's certainly something the court considers as one of the ways of deciding whether this agency's interpretation is actually making law, making in practice, and or whether it's not, whether it's just the agency making a decision about an individual's case. Okay, let's go back and finish up. We have a quick review question. If Chevron deference doesn't apply to an agency's interpretation of a statute in a certain case, it does not apply, does the agency still receive some degree of judicial deference? A, no. If Chevron doesn't apply, then the court undertakes de novo review. Or B, yes. If Chevron doesn't apply, the court will still afford what we call Skidmore deference instead. Hopefully you know the answer to that. If you don't, you haven't been paying attention and you need to go back and review this video. And that concludes our lecture about US v. Mead.